Tonight I've just got some important tips for you if you're a business owner, or maybe even someone looking to be a business owner who wants to think and plan out in advance how they might exit the business. And so what I've got is some tips for you if you're looking to sell. Number one, the method of sale. The method of sale can be one of two main methods. The first method is where you actually sell the business assets themselves, whether that's vehicles, plant and equipment, intellectual property type assets, selling them from the seller's entity to a new buyer's entity. The second method is where the seller sells its interest in its entity, for example, selling the shares in its company or selling the units in its unit trust. Point 2, due diligence, looking at the buyer. As a seller, you may want to consider whether the buyer is going to be able to obtain finance. Naturally, if they can't obtain finance, unless there's another way we can go about it, it may end up being a waste of everyone's time. It's also often wise to look at whether the buyer has a sufficient financial standing and experience running a business of the type that you're selling, as your landlord may actually have requirements of its own regarding the financial respectability and the ability of the buyer to continue to meet all of the obligations under the lease. Point number 3, confidentiality or non-disclosure agreement. A prospective buyer may request various confidential or sensitive information. It's often a good idea to talk to your lawyer or accountant about this information and what should or shouldn't be released. Secondly, you might like to consider drawing up a confidentiality agreement, also known as a non-disclosure agreement, especially in the US, to help safeguard your information. Number 4, the structure of the deal. How is the deal structured? Is the deal plus stock or is stock included, sometimes called walk-in, walk-out? Often it's a good idea for your lawyer to chat to your accountant to make sure there's consensus as to how the transaction is being handled from a GST perspective. Is there a GST tax invoice required? That's something important not to forget. Is it capable of being a going concern? You should of course get legal and accounting advice at the time, but to oversimplify, in order to be a going concern, both parties generally need to be registered for GST or required to be, and the seller must supply all of the things necessary for the buyer to continue the operation of the enterprise. Number 5, your lease. Consider whether there are any make good or refurbishment clauses. Is the term of your lease current or has it expired and you're currently a month-to-month tenant? Are there any unexercised options which you may need to get in an exercise to extend the term of your lease so that your lease is more attractive to the buyer? Should the lease be registered on title if it isn't already? What will the buyer want? Having a pre-sale lease checkup is a really good idea because often it can affect the whole sale process and the ultimate outcome. Number 6, plant and equipment. What condition is your plant and equipment in? If it's in not so good condition, do we need to have some special conditions to describe exactly how it is and that the buyer is happy with that? Is the plant and equipment unencumbered? One of those weird words, but just meaning that no one's got an interest over it, a bank or a finance company or something like that. If there is such an interest, does that need to be paid out before the sale settles? Or is the buyer willing to assume that liability and step into your shoes and perhaps continue making payments on that plant and equipment? The key is to just understand what the situation is and make sure that the buyer and seller are on the same page for the deal. 7, intellectual property or IP. Consider the goodwill assets of your business, like intellectual property. For example, registered business names, domain names, phone numbers, trademarks, patents, etc. A really good first step is to ensure that any registrations have not lapsed or expired. Due diligence, looking at the seller. Consider what it is that the buyer would like to look at. Do they want financials from the past 12, 24, 36 months? They might want to know more about your intellectual property. What's your website? Who hosts it? What social media accounts do you have? Other information a buyer might be interested in includes utility accounts, supplier or customer details, and insurance particulars. Have you been trading relying on verbal or handshake agreements? Because now might be a good time to actually reduce those to writing and solidify those so that the buyer has more reliability about those agreements buying the business. Number 9, employee entitlements. what is currently owing to your employees. Up-to-date information will need to be available so that we can calculate the employee entitlement adjustments for settlement purposes. What documentation is currently in place with employees? Are there employment agreements? Are there policies? Does the buyer want to continue these arrangements? Number 10, restraints of trade. A buyer paying for goodwill will often want the seller restrained from opening up a similar business down the road 2 minutes after settlement. Often the contract will contain a restraint of trade. There are typically two factors to a restraint of trade. Firstly, an area restraint, for example, a 25-kilometre radius, and secondly, a time or temporal restraint, for example, 1 year, 2 years, 3 years, etc. Generally, to be enforceable, these restraints will need to be reasonable. And what's reasonable depends on a range of circumstances. But, for example, if a buyer pays a really high premium for the business, they pay a high price, a lot of goodwill, then what might be reasonable might be quite an extensive restraint. Whereas if the buyer is paying a really low price, a reasonable restraint might be somewhat less. As a seller, what are you willing to offer? Because if you offer a larger restraint, maybe that means that the buyer is willing to pay that little bit extra to know that they definitely won't have any competition coming from you anytime soon. Also, as a seller, if you know that you are going to perform certain business activities in the future and you need to have permission to do that, it's often a good idea to include a carve-out of the restraint of trade, which just means including some specific wording to make sure that you can do the thing that you're planning to do. Hey, thanks very much for finding this video and watching it to this point. I really do appreciate it. I hope you have a great day, a great night. If you'd like to keep an eye out for future videos, feel free to click the subscribe button. If you have any questions, feel free to flick me an email. That's it for today. Cheers. Fox out.